Yes, ma'am.
If I may ask a question as a supplemental to the question that my learned brother, my learned colleague has asked. Independence of the judiciary is a recognized fundamental right.
Yes, ma'am.
So the question, surely, this is the question to you. Surely, the question of what the court can itself do to regulate its own practice and procedure is now encased in independence of the judiciary, and can Parliament intrude upon, with all due respect to Parliament, they have their legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191, trample upon, I'm using this word a bit deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect the independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself?
Yes.
Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution, and the Constitution says independence of judiciary is a fundamental right. Can Parliament directly or indirectly take away a fundamental right?
आप नोट कर लें,
if I will really request my colleagues that they are making, including myself, are making your life impossible. No, please, no, you are very fine.
I'm learning.
No, we are not here to teach you anything. You are here to help us. Now, please, we're not even reading the act, and we are getting bogged down into details. Let us go through it, formulate your contentions. We will bombard you with 100 questions. You respond to them later. You respond to everything, then the matter gets lost. Again, we are stuck with section. We are not even making progress. Please continue in your way.
आगे बढ़ते हैं. Let me say this.
Mr. Khawaja,
Khawaja sahab, section 5 से आगे पढ़ लीजिए.
Another question with regard to appeal. आप देखें, हमारे पास already एक dictator का ordinance था, Law Reforms 1972. उसके तहत Article 199 के लिए appeal provide की गई before 2-member benches. We are following it. क्या वो जो डिक्टेटर का था वो दुरुस्त है और पार्लियामेंट अपील का राइट नहीं दे सकती? वहाँ तो अपील का राइट दिया, सेम प्रोविजन कॉन्स्टिट्यूशन, आर्टिकल 199 है, आर्टिकल 183 84(3). तो ये क्या दोनों में
Sir, it is
गलत है तो फिर वो भी गलत है.
It is not we'll answer this thing that what Parliament can do and what Parliament can do many things. Why my Lord has said so, but there is the procedure provided. Will answer that.
भाई साहब, अभी जो आपकी जरूरत नहीं है, आप
I will not answer it.
पहले एक्ट को खत्म कर
Section 5 से आप आगे पढ़ लीजिए.
Khawaja sahab,
You have collected 100 questions.
Just here, the law reforms ordinance of
I don't think how you will
1972.
answer.
This is the question to you. Regulated a right of appeal within the High Court itself, an intra-court appeal. Was there ever a clog on the jurisdiction and on the legislative competence in relation to jurisdiction and powers of the High Court in the same manner as it is in the Supreme Court? As I read it, the clog is there only in respect of the Supreme Court. Law Reforms Ordinance didn't do anything with the Supreme Court. It only affected intra-court appeals within the High Court, both in the concurrent list, which is now no longer there, and also the clog was only in relation to Supreme Court. Question: is therefore the Law Reforms Ordinance of 1972 a parallel valid example which relates only to the High Courts, a valid parallel example in relation to what Parliament seeks now to do in the 2023 Act? This is the question. With relation to the Supreme Court, where there is apparently a clog.
Mr. Noted, sir. And appreciate. Section 5. An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days be fixed for hearing. And second part, the right of appeal under subsection 1 shall also be available to an aggrieved person against whom an order has been made under clause 3 of Article 184 of the Constitution prior to the commencement of this Act, provided that the appeal under this subsection shall be filed within 30 days of the commencement of this Act. I'm not going to analyze it. I have my serious objection on this, and I will.
What you have to do, you're saying I'm not going to do it.
My lord,
You have challenged the
my
law,
lord,
you have
my
to do,
lord,
you have to challenge
that
it.
Appeal shall lie within 30 days.
We've read the English of it. What's wrong with it? Tell us that.
My lord, as far as section 5 is concerned,
Is it good? Is it bad? First tell us that.
Well, it says that appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of 184. May I respectfully submit that if an appeal is provided against a decision under 184.3, then why is this not they included in clause 2? Whereby my 184.3 application will be disposed
Is that
of.
the way I was taught law was not the council asked questions from the bench. It was the bench would ask questions. Are you supporting this provision or not? First say, yes, I am. No, I am not. These are my reasons.
My lord, I have a reservation on this.
You may have reservations. Tell us what's unconstitutional about it.
But then let me explain it to them, because if I start explaining it at this stage, it will take your time. But I will say this thing, that this section 5 should have also, this right of appeal should also have been given in section 2.
Should is different from ultra vires, the
It ought to
constitution.
have been given.
What then you go and move a bill in parliament. We are saying, are you opposed to section 5? Give us legal reasonings, or you say it's okay. अब उनसे आप पूछेंगे
You have done this.
नहीं ये नहीं आप जवाब दीजिए ना आपने पिटिशन लाए this is not fair.
To make it more simple, you don't want your client to have a right of appeal.
No, sir,
If first say it's unconstitutional, it's constitutional, you're not saying anything, you just यहाँ कोई discussion होता है, sorry, not on. This is your job in office.
My lord, may I say this thing that we divided the.
Please answer the question, is this constitutional or unconstitutional? I can't hear you.
वायरिस तो बताइए ना, वायरिस क्या है?
Hey, unconstitutional आपके जहन में और नहीं है?
Unconstitutional.
Well, my personal opinion is this, sir, that this section 5 goes beyond the powers which were there with the parliament.
So now formulate a contention on that. Please formulate a contention.
For the simple reason, my lord, if an appeal is to be provided, it's a substantive right. There has to be a constitutional amendment to provide an appeal under section 184(3).
ठीक है,
Because
okay.
that, and this appeal through this act, an ordinary law, cannot provide.
I can't seem to reconcile your, which I appear to me to be contradictory submissions.
No, I'm simply saying
Please
that-
let me finish.
that-
Please let me finish.
Yes, ma'am.
On the one hand, you are saying, where will I go? Where will I go? Here, the parliament has given you a right. You say it's unconstitutional. So please don't make contradictory contentions.
I'm only saying this thing, that it's a good thing that the right of appeal be given, but the manner in which it has been given
Man,
is
take it,
wrong.
please take it.
And
No.
I'm saying this thing, that this one, the right of appeal given in this manner by an ordinary law.
We will not strike it down because of manner. You have to show us ultra vires the
It is
constitution.
unconstitutional, sir.
But saying so, no argument.
My argument is this, that 184(3) is a substantive provision of the Constitution. If
You are happy with no appeal.
If a right of appeal has to be given, there has to be a constitutional amendment.
Okay, point taken. Move ahead.
ठीक है,